Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana.
Hello, lovely people. It's another wonderful Saturday afternoon, and we are live on the Community in the Law, live on BWTV and BWF Solicitors. My name is Oreku Frimpon, and I'm inviting you to come along on this International Women's Day to have a very lively discussion coming from the stables of BWF Solicitors. And what are we going to look at now? Get ready. We're going to do some calculations from A to B, from day one to the end, and from the middle of a situation to the end. And don't get confused. We will tell you what to do and how to do that. It's the Community and the Law, brought to you by BWF Solicitors. Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello. Do you know when you are due for your indefinite leave to remain here in the UK? Do you know how to calculate it? What gives you the indication? And when it is that you are due, what do you do and how do you do it? These are questions we are going to find answers to this afternoon on the program The Community and the Law, and it's brought to you by BWF. Solicitors are trusted partners when it comes to the law. BWF Solicitors is on the 4th floor of Vienna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call them 0208 493 7340 and speak to them about any of your legal matters, especially when it comes to immigration issues. BWF Solicitors, they understand your language, they know the strategies, they have all the updates that there are. And of course, if the situation is something they can't handle, they will tell you straight away in their face and say, listen, this is a situation we can't handle and you may not succeed. So definitely let us not pursue it. But if there is a chance that you will succeed, definitely BWF Solicitors will do that for you. And that's why we are so confident in them and they're so trustworthy to help us do that. BWF Solicitors, we thank you for that. Now this afternoon, we are here to give you hope, give you encouragement, and also empower you to know what it is that you have to do when it comes to immigration matters, especially. And today as I mentioned earlier on, we're going to talk about indefinite leave to remain. Do you know when your indefinite leave to remain period is up and when you are due for that and how to do it? We're going to do some calculations I've mentioned, and I want to repeat that. Well, this week I tried doing that. Um, then again, when we get to the stables of BWF solicitors, they will tell us what the law says. So we don't do it wrong. The law, the Home Office guidance, and of course, our common sense as well. But before then, let's pick up what our rights are. You know that on this program, at the start or the second week of the month, we bring you what your rights are. But alas, we have to let you know that we are celebrating International Women's Day this very 8th day of March 2025. And our women, our mothers, our wives, our sisters, and our siblings, our female siblings, are on the platform, and we saying congratulations to you. The woman is important. When it comes to the African setting, the woman is the base of the family, and they spread from there. When you go to Ghana, to the Akan tradition, people take their lineage from the feminine side. Why? Because that is where it spread out. And definitely, if it is that internationally we are recognizing what they do, we salute our women. And you can see on our screen the beautiful ladies of BWF Solicitors, the smile, the elegance, the warmth, and the sense of welcome. That is the woman. I am proud of the women I deal with, I work with, and I'm proud of my mom, my sisters, my wife, and the rest of the family. International Women's Day, we salute you. Thank you for what you do for us, all the women in the world. And if you have influenced us one way or the other, we are saying we thank you. Thank you, our women. Lead the world, and it will be a better place. International Women's Day and BWF Solicitors, BWTV, and of course the community and the law, we are celebrating our wonderful women. Today, the 8th of March, it's your day, and we dedicate the program to you, our wonderful women. Okay, so having done that, we would want to also show the kind of appreciation people are expressing to BWF Solicitors. And this one is from Sexy, who says that he's worked with Charles Asma, and it quite a smooth and seamless process. He says that from the booking of the biometrics day to getting the decision on the FNR, everything was smooth, everything was nice, everything was successful, and so happy that he would want everybody to know. So he says, kudos, Charles, and keep delivering for the BWF team. I trust many more wins lie ahead of us. Seth, thank you very much. And definitely, Charles is on with us this afternoon, and I can see the smile right from left to right is so broad. And BWF Solicitors is also proud to have worked with you. So, Seth, thank you, and keep it coming. Those of you who have those lovely stories and some feedback for BWF Solicitors, you can visit us on our various social media platforms, Facebook, YouTube, um, TikTok, and all the other bits. Or you can send that to our emergency line by text 077-127-61884. Call us, tell us, or go to Google and then give us your review there. You go to our website, bwfsolicitors.com. You can do that there as well. Thank you very much, Seth. We appreciate you as well. Well, let me see. Do you know you're right? Do you know that there are certain things that you need to know? And those are things that would help you in your academic life, in your professional life, in your family life here in the UK, and all the other bits. Now, let's look at these things that would definitely be of benefit to you. Let's start with this one. The UK offers a range of visas, each with specific rights and conditions tailored to different categories of migrants. So I could look at skilled workers, temporary workers, innovator founder, and global talent visas. These are opportunities for you to go through to regularize your stay here in the UK. So I will take them one after the other. The skilled worker, this one is designed for skilled workers who have received a job offer from a UK employer with a valid sponsorship license. Holders of this visa are permitted to work for their sponsoring employer in the role defined in their certificate of sponsorship. The visa typically leads to settlement in the UK after 5 years. Okay, now let's see those who also come to work for a very short period of time. We're looking at several subcategories that include youth mobility scheme, the creative workers, charity workers, religious workers, government authorized exchanges, and all the rest of that. There are restrictions associated with this visa type, and permission to work may be granted for 12 to 24 months. But listen, they do not lead to settlement. What are the other ones we have? Let's look at the next category that we have. Um, Innovator founder, that's another one I mentioned earlier on. And this allows foreign nationals to establish innovative businesses in the UK. To qualify, applicants must obtain endorsement from a UK approved endorsing body, which evaluates the business ideas, potential for growth, and contribution to the UK economy. Remember that. So, if you have anything to do, if you have an idea that can generate business, go into a business realm, listen, if it is contributing to the UK economy, it could be considered. So, if you're an innovator, you think of several other things you want to bring up to help improve the lives of people, generate money for yourself, it could be considered. Then there is the Global Talent Visa, where um, we look at one for recognized or potential leaders in academia, those who do research, arts and culture, digital technology, and all those things. So if you can code, yes, you can use the IT instruments to generate some working idea. Why not? Look at that. I'll be asking lawyer to kind of explain to us how we can go about applying for some of these types. This one, the Global Talent Visa, I know offers significant flexibility, allowing holders to work for various employers, either as self-employed, and also allows you to change jobs without needing to notify the home office. That's a good area. I'll ask you to do that. So let's look at the next one quickly. So having looked at these categories of visas, let's look at your rights and responsibilities. I'll take the skilled worker visa one. One of the main restrictions, as I understand, for skilled workers is that they can only work for the employer who sponsored their visa. They must remember to follow the job role and conditions specified in the certificate of sponsorship. If they wish to change their employment, such as moving to a new job role or a different employer, they must obtain a new certificate of sponsorship and submit a new visa application. We have been going over this over and again. So take note of that. Now let's look at the innovator visa, so to speak. You do not have to have a minimum investment threshold. Okay. Unlike earlier visas, the Innovator Founder visa is accessible to entrepreneurs from various financial backgrounds without imposing a minimum investment. Additionally, remember there is flexibility in running a business, including the type or the right to work outside of the company. So an accelerated path to indefinite leave to remain is, I understand, available within 3 years. Yeah, I would want to go through that. Think about that. Then we have one that says bereaved partner, and the key requirements: you must already be in the UK. You must have held a valid family visa with your partner. The partner must be a British citizen or Irish citizen and have pre-settled status or has been a refugee. So there must be a status that's kind of recognized. Provide proof of genuine relationship before the person passed on. So that is another visa type, that's a bereaved one. Then let's look at common restrictions for all work type visas. And some of these include not accessing public funds. You must adhere to specific job roles and sectors outlined in the visa conditions. Then you must also comply with the maximum work hours stipulated by the visa type. So look at that critically. So if you're switching to these categories, individuals currently in the UK cannot apply to switch to the skilled worker visa if they are on a visit visa, on a short-term student visa, if you are on a parent of a child student visa, on a seasonal worker visa, on a domestic worker, in a private household visa, on immigration bail, you have been granted permission to stay outside the immigration rules, such as on compassionate grounds. If you fail and or if you fall, so to speak, under one of these categories, you must leave the UK and apply for a skilled worker visa from abroad. So this switching is a bit complex, and I know would have a way of dealing with that. But I would recommend that you speak to BWF solicitors. So obviously, if you're planning to come to the UK on a work visa, the BWF solicitors experience team is available to help you. The contact numbers are on your screen now: 0044208 493 7340. If you are in Ghana, you can go to the Ghana office or call them on 055 589 5959. In emergency situations, I keep saying call 077 127 61884 or visit BWF Solicitors on their website, bwfsolicitors.com, or on all the social media platforms at BWF Solicitors. Okay, so having said that, I will want you to really look at what we brought to you as a nugget earlier in the week. Today, we have a lot to chew on, but listen, when we come to that discussion, it's a very interesting, straightforward one that is talking about your indefinite leave to remain, whether you do and how you can go about it and all that. But the question is, did you know that whether you see your child or not, you have a legal duty to support your child? I can't really say, there's something that is coming your way, and definitely it would come to bite you if it is that you are not living up to your parental responsibility. Now, let's look at this. In the UK, child support or maintenance is a legal obligation for parents to pay their children's living costs. This applies even if the parents don't live together or have no contact with the child. The Child Maintenance Service can take enforcement action against the paying parent either through a deduction of earnings order or a court order, including, that's critical, including seizure of goods, disqualification from driving, or committal to prison. The Child Support Enforcement Act was updated in 2023. And listen, if you have a son, you have a daughter, you have a young person you're taking care of, and you neglect your duty, whether you see the child, when you have contact with them, or that, you are obliged. There's a legal duty for you to support that child. So if you are reported, the Child Maintenance Service can take enforcement action against you, and it could be they will deduct your the money from source. There could be a court order that seize your goods, disqualify you from driving, or commit you to prison. If you are neglecting your duty, I'm telling you, is one of the rights of the children. That's what I've told you. Well, with this, let me say, just introduce you to my social media platforms, and when I come back, I will be throwing all the questions to lawyer Charles Asma, resource person and guest this afternoon. It's the community and the law. Welcome back, and thank you for sticking around. It's the community in the law on this very lovely Saturday afternoon here in the UK. We are right in the heart of North London, Seven Sisters to be precise. Get on the train and get to the fourth floor of the other house when you alight at Seven Sisters train station. Use the exit number 2 and come to us at BWF Solicitors. That's where your immigration problems will have a stop and turn around to be a successful one. Well, this afternoon, as I said, by courtesy of BWF Solicitors, we're bringing you this discussion, and we have from the stables of this wonderful and reputable organization, lawyer Charles Asma, to help us do our discussion and, of course, lead us into doing the right things when it comes to these applications and some of the updates we have. Asma, good afternoon.
Good afternoon.
Thank you very much for joining. Um, it's I nearly said something, but well, it's like the piano this afternoon. There are the white and the black keys. Watch this.
Interesting,
It's very interesting, isn't it? Yeah. Um, the black and the white keys go together to make a melody.
Interesting.
So this afternoon we have a good melody for our viewers. Thank you for joining us. We appreciate your time. How's the family? How's work? We thank God for all the mercies. Well, I have taken our viewers through some of the rights, especially when it comes to the various visa types. There are some conditions in there. I think it's the seventh slide that I touched on. It talked about some of the things people can do and cannot do in there. If we could have that on there, we can refresh our minds as to what it is. Restrictions there. Yes, I think that was the one. We can look at the number 7. Well, 3, 4, 5, 6, 7. Yeah, that's the one. You got it. Anyway, common restrictions. Not accessible to, or you can't access public funds. You have to adhere to the specific job roles in the sector that you had in, and then compliance to the number of maximum working hours and all the rest of it. So does it mean that if I come here with a certificate of sponsorship, does it mean that if I am on an innovator visa and the rest of it, I can't access public funds?
Right. So public fund simply means taxpayers' money.
Okay.
Even though you may be paying tax, your tax was not meant to look after you.
Okay.
Your tax is meant to look after the streets, build new roads, support general stuff within the country,
Okay.
including supporting those who are ordinarily not able to earn, like yourself. And so the point is that if somebody is entering the UK, be it to join a family, be it to work, school, whatever it is, you are not entitled to public fund. So when you are applying, you'll be asked to confirm that you can look after yourself. If we're applying to work in the UK, either your employer must confirm that they are guaranteeing maintenance for you, or you should be able to confirm that you are able to maintain yourself. So in terms of public fund, if you are not eligible and you go for it, it's an offense. It's a breach of your immigration condition. Again, the job type that you sought. If you sought to enter the UK as a nurse, you should be working as a nurse. You cannot be seen to be doing something else. The law allows you to do 20 hours top up, but that does not replace the main duty. So we take note of that. We've touched up on the maintenance, the fact that you should be able to maintain yourself so that you do not fall foul of the public fund access restrictions or the rules.
The other bit that I wanted a little clarification on, and I'll be putting this on the screen in a moment, is talking about switching to these categories. And we're looking at individuals currently in the UK cannot apply to switch to the skilled worker visa if they are the 7 of those categories down there: on a transit visa, short-term student 1, parent of a child student visa, on a seasonal worker visa, and the rest of it. Why those restrictions? Does it mean that if I'm switching to the skilled worker route, then I have to go outside of the UK to apply for that? Can't I switch inside whilst I'm in here? on a different visa, so to speak.
Yeah, it simply means you cannot do it. But why can't you if you're on any of these categories? So we take them in turns briefly.
Okay.
So the first one is you enter the UK as a visitor. Remember, it's always the expectation of entering the UK.
Okay.
If you enter the UK as a visitor, what's your expectation?
You came in to visit and you're going back.
So why will you then decide to switch?
I come in and I find an opportunity.
So the intention should
Mm-hmm.
supersede any opportunity that arises.
Okay.
And that's why if you're a visitor, you cannot switch. Because visitor's visa is not a switching visa.
Okay.
Because you don't intend to live more than the time you were granted to enter the UK.
Yeah.
So the next one is, can just take me through. The next one, what's the next one?
The parent, okay, the short-term student visa.
So short-term student. You see, it didn't say student, it said short-term student.
Mm-hmm.
So short-term courses, 3 months, 6 months. You don't intend to come and stay for longer than that short period.
Okay.
And so you cannot switch, even if there's opportunity. You are as good as someone who is here for that specific reason. Yeah. The next one
is a parent on a parent of a child student visa.
So parent of a child. Now, so we have adult student and child student. A child student will normally need an adult to support their day-to-day and also guide and support them through. So if you're a child student, you're allowed to bring your parent or a responsible guardian with you. But what's the role of that guardian? To look after the child as a guardian. So to the extent that the child is a student, you qualify to be in the UK. If the child has completed and the child is supposed to go to the country they came from, should you stay?
Well, then no.
And so you cannot bypass your core duty of a carer or guardian to switch to something else.
Okay. All right. The next one, it says seasonal worker visa. I would want to say that when we were looking at the category on the seasonal worker, it says it could last between 12 and 24 months. So then it's for a short period. So then does it go to say that if you are on that one, then definitely you cannot stay beyond that bit? I think it goes to say that.
So the short term, or we call it seasonal workers. You know, those who come to pluck tomatoes and work on farms, and those are the seasonals. So winter there's a job for certain things, summer there's a job for certain things, and once the period is over or the season is over, you have to leave. Go. And so if you're a seasonal worker, you don't have the expectation to stay beyond the season.
Right. Okay.
So why would you then switch to go past the season? So
so if you really want to change, then you have to go out and come back.
Exactly. So all these categories. Now the reason why this is important is that some people will say, okay, my visa hasn't expired. I have heard about switch if your visa has not expired. So why can't I do it?
Yeah.
And therefore, under the spectrum of knowing your rights and duties in the UK, it is your right to enter the UK as a visitor or any of these categories. But it doesn't fall within your right to switch to something else.
Okay.
And if you want to switch to something else, you have to go back, get a proper visa, come back in to be able to switch in the future.
Okay. Well, thank you for this, but I'll go to want to add a point?
I think the word proper I use there is used in context, and proper means that different, that suits switching purpose.
Oh, okay. Yeah, I keep saying, I think I mentioned last week that when it comes to legal terms, even dotting an I could mean something else. So then you put in proper context. Now, the nugget, as we had it, mentioned that it's a legal duty of any parent to support their child. It's saying that in the UK, child support or maintenance is a legal obligation for parents to pay for their children's living costs. This applies even if the parents don't live together or have no contact with the child. It has always been the situation that child maintenance is taken from men. Am I assuming wrongly?
Okay. All right. Now, the question is, we have a child, we have parents.
Okay.
So ideally, there will be two parents. Or
Yeah.
there could be some quasi-parents, but in this context, we are looking at the biological parents. So father and mother. Ordinarily, if the father and the mother are living with a child, then there's no problem, or there's no problem, or there's no concern as to how the child should be looked after.
Okay.
So nobody will know your business. But if one is not in that context or in the family unit, then the question will be, what should be your role now that you have decided not to be part of the family unit?
Okay.
So the child may be living with the father, or the child may be living with the mother. If the child is living with the mother, he says that, yes, child maintenance mentions the word father, but it doesn't necessarily mean only fathers. So it depends on the pendulum where it swings.
That's right. Okay.
So if the mother is the one looking after the child, then the absent parent should be able to play a role in terms of maintenance of the child.
Okay.
Because you made it happen, so you have to make it happen better.
Okay.
And so if you have brought a child into the world, you have to be part of caring and maintaining the child.
The assumption is that the pair of them would take care of the child. So if the absent parent is going to be giving an obligation, their bit, would it have to be an equal percentage of what the child was to have earned that will be taken from that absent parent? Or it has to be because that parent has been absent, the whole responsibility is put on that person?
Not necessarily. I mean, there are instances where child maintenance service will not even know the business of the parents, whether they are living together or not, because they are responsible and they agree that every month X will be made available to the welfare pot for the child.
Okay.
So if you are paying, that's it. But if you are earning more and you decide to pay less, that's why the other party will feel that they are being shortchanged.
Okay.
And so the person will make a complaint to child maintenance. So one, the person has abdicated responsibility to maintain the child. The other parent will have a choice to go to child maintenance, or the parent is supporting but not enough, even though they can afford more.
Okay.
So once it gets to child maintenance, they are supposed to assess your income and say that based on your income threshold, you have to be able to pay X amount.
Right.
What if you decide not to do it? That's not a big deal. If you don't want to do it, they will just want to know where you work. And they will tell the employer to deduct at source automatically.
That's what the act is saying.
That's one. Or it becomes an issue where you have to be punished for because it's an obligation. Then you are in breach of a certain aspect of the law to the extent that it can even go against you in some respect, as has been mentioned. But the long and short is that if you don't support the maintenance of your child, the law says that the other parent can inform child maintenance service so that the payment can be deducted at source and directly paid to the child bank account or the other parent's bank account for the child. What does this tell us? It means that you cannot give birth and abandon responsibility.
Okay.
And can be scary, isn't it? For example, if my child's birth certificate shows that you are the father named there for whatever reason, your name is there as a father. Can we fall on you or call on you through the child maintenance service to pay? Of course, because you are the father.
The father, yeah.
I'm not going to go further into that, but that is how.
No, but then there must be a report from the present parent that the absent parent is neglecting their responsibility.
Of course, you may be neglecting your responsibility. That's why the other parent will report. But we are looking at the general scope where it is the case that you are the father. That is, but if you are the father, you are not doing what you have to do. But here, the advice goes to everybody who is a parent named on the child's birth certificate.
Yeah.
That if you don't commit to your side of maintaining the child maintenance service can fall on you, your income, and make what we call deduction of earnings assessment and take the money as source, or some other punishment can follow.
The child maintenance service, as lawyer has said, can take action against the paying parent, either the non-paying parent, either through a deduction of earnings order, a court order, including seizure of goods, disqualification from driving, or committal to prison. Okay, so I have this scenario where I have the Mokoso, briefly dated Layla, and they had a child named Zaina. Layla requested child support from Mokoso, but then Mokoso refused, claiming that he had been denied access to their child. This case was brought to the Child Maintenance Service, which determined that Mokoso should pay £450 per month based on his income. However, he refused to make any payment for 2 years. The question I'm asking is, what options are available for Layla or the Child Maintenance Service to collect the arrears? 1, urge him to pay as the child is in need. 2, nothing. Since Layla had denied him access, he has a right not to pay. Then 3, potentially pursue legal action to imprison him for non-payment. That's a strong one. Which one is the correct answer? Think about that, because I'll be asking you to give me those answers at the end of the program. It's a Community on the Law is brought to you by BWF Solicitors. This afternoon, I'm going to ask you a very interesting question, and then you don't answer, because Lawyer Charles Asma is here to help us find the right answer. Do you know when you are due for indefinite leave to remain in the UK? Check what the law says after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. I know those of you who are on there, you are really enjoying the discussion so far. Let me recognize you. and say thank you to you. So if you're on there, let me see you. Keep your comments in the comment section down below, either on Facebook and YouTube at BWF Solicitors, at BWTV. Kwame Dot, good job. Keep it up. Thank you very much, Kwame, for sticking around with us. Tilly, hello, lovely family. Tilly, thank you as well for coming on every time. Nanaji, my senior minister, come. The class is ongoing, so you're all being invited to. Charles Emery, thank you, Charles. Good afternoon to you. Yes, your namesake is here and is going to help us with the information and the strategies. Good evening, everyone, from Becky Amako. My partner is due for an indefinite leave to remain on the 10-year route. She has a CCJ or a debt. Would that affect the decision? We'll come back to that later on. Rachel Zosma will help us answer that. Kindly share, comment, and like. Thank you. Thank you, Tilly, as well. Wumpini Adam, good evening. BWF Solicitors. Yes, good evening to you, Wumpini. I hope Accra is fine and doing you good. What form can you use for your children application of indefinite leave to remain family route? Okay, McDonald, we'll come back to that and answer. Yes, so if you're on, let's see you, let's hear from you. Say something down there in the comment section. But remember to like the page, share, and comment as well. Lehasma, good afternoon once again. We're talking indefinite leave to remain. What's that?
Thank you very much. So indefinite leave to remain is, I call it, the last attempt into immigration independence in the UK.
That's an interesting one.
Because you've gone through the process, you've gotten to a point where you deliberated so that there will be no immigration restriction.
Mm.
So once there is no restriction under immigration rules placed on you, you are independent. At that point, we say you are present and settled.
Okay.
That's the law, or how the law defines somebody who has gotten to that point, present
and settled.
So when you are applying to settle in the UK, we call it settlement application or indefinite leave to remain.
Mm.
So indefinite simply means that a status that places no immigration restriction on you. And we know that within the immigration rules, the Secretary of State is supposed to ensure that there is legal migration, and as far as it can, ensure that legal migration can be curtailed or can be managed. And so if somebody has gone through the process and has been granted indefinite leave to remain or permanent residence in the UK, the person has no restriction as far as immigration rules are concerned.
Let me then get this. I think the clarification would do our viewers, clients, and our friends some good. If I have no restriction on my stay here in the UK, does it mean that I am a citizen of the country?
No.
Okay.
You are not a citizen. Citizenship is a choice.
Okay.
And so you are already a citizen of a particular country. And if you like, within the rules of your adopted country, you can apply to become a citizen of that country. So we have your primary country and the adopted country.
Okay.
As far as your primary country allows for dual citizenship, you can become a citizen. So indefinite leave to remain, you are still a foreigner without restriction in the UK.
Okay.
Citizenship, you are a foreigner who has become a citizen and therefore has rights as if born in the UK.
Okay. Right. So then our question we're asking this afternoon, do you know when you are due for? So it means that at a point you may not be having, or you may be having a restriction on your stay. Then it gets to a point that the restriction will either be removed or be over. So the question is, what what do I need to know and see that will tell me that at this point my restriction is taking off? So indefinite leave, how do I get it? Where do I get it? And how long do I have to wait till I get it? Maybe that will help us.
Thank you very much. So I'm going to go through some terms because we've been using or hearing about those terms. So FLR means further leave to remain.
Okay.
FLR, further leave to remain. Whether further leave to remain as somebody in the UK extending leave to remain, or further leave to remain as somebody who once became an overstayer and wants to regularize. It doesn't really. So further leave to remain simply means you want limited stay. We have further leave to remain, FLR.
Okay.
We have limited leave to remain, LTR.
Okay.
We have indefinite leave to remain, ILR. Most people know ILR, indefinite leave to remain. We have permanent residence, which also means indefinite leave to remain. Then within the spectrum of various provisions of the law, we have Appendix FM, which is appendix to do with family migration. And we have Appendix UU, which is appendix to do with the Brexit agreement under the Withdrawal Agreement Act 2020. Now, under the Withdrawal Agreement Act 2020, if a EU national is going for indefinite leave to remain, we call it settled status.
Okay.
So you've heard about settled status. The settled status is the term under Appendix UU.
Okay.
But in terms of the meaning of the word, it also means indefinite leave to remain. Or permanent residence. So when you are applying for settled status, for me as a lawyer, I understand that you are applying under Appendix UU.
Okay.
From pre-settled 5 years
to settled status. Okay.
Pre-settled 5 years also is limited leave to remain. But because we are dealing with a specific provision, which is an Appendix UU, we say pre-settled status, because that is the term couched under the withdrawal agreement. That to be settled, you have to become pre-settled.
Okay.
But in the same way, under Immigration Rules Appendix FM, which is family migration, you'll be given 2.5 and another 2.5 as a spouse, for example, another 5-year route. You also be given 2.5, another 10-year route. So these are all the basics to indefinite.
Okay.
Somebody will ask, what's the difference between 2.5 under 5, 2.5 under 10? Simply, when you are applying for leave to remain, you have to meet the rules. One of them is relationship, which cut across, it doesn't matter. There must be a relationship, unless it's a private life, which you don't have to show relationship of somebody you are relying on to apply. So that one is private life. But if it is to do with a parent, then you have to show relationship with your parent. If it's to do with your child, you have to show relationship with your child. If it's to do with your wife or spouse, you have to do relationship with your spouse. Now, so we're looking at relationship. We're also looking at financial requirements, which is at the moment 29,000. We know it used to be 18,600. It's moved to 29,000. And therefore, if you are able to meet 29,000, you're able to meet relationship, you are able to meet accommodation, you are able to meet English language, B1 or A1 from abroad, then you should not be put on the 10-year route. Because
then everything that's required of you, you have ticked all and everything is in place. So you do not have any shortfall, then definitely maximum 5 years, you should have your higher ceiling, isn't it?
Your journey. So the journey up to 5 years, but you'll be given 2.5. So cut into 2. 2.5.
So then you start midway, you have to renew,
and
then finish off when you get to your 5 years. When you have met all the conditions, ticked all the boxes.
Yes.
Okay.
So this is under Appendix FM, 5 year to settlement. 5 years to settlement.
Okay.
That's the journey. So what about somebody who cannot tick all the boxes? What do we do? Ordinarily, If you can't take all the boxes, then you don't get anything. Because meritorious.
Okay.
Take and get. If you can't take,
You can't get.
But what if genuinely I can't take? And for whatever reason, you have to consider me. Then we can't consider you under the points. We have to consider you under something. We call it discretion.
Oh, okay.
And that discretion, we look at the law and we look at, for example, Appendix FM, paragraph EX1. Says that if you don't meet some of the rules or the points under 5, you have to be considered. If refusal will be harsh, you have to consider it under the discretion. Discretion, then if somebody is going to be granted on discretion, then the advantage should not be the same as somebody who worked hard. Otherwise, it will not be fair.
It will not be fair.
And so, if you are not able to work hard to take the box, you'll be put on a 10-year route, 2.5, 4 times. So, if somebody applies and the person is granted, even though they did not meet money requirements, finance, but they were not able to meet English language requirement, they will still be granted because there's a child. Or there are other reasons. Then the person will not be given as if they worked hard for it. So not working hard, a 10-year route. Working hard, the question will be, what do you mean, lawyer, by working hard? It means meeting all the requirements. Especially money, 29,000, and also the English language.
Okay.
So we have seen somebody who is journeying onto immigration, going through the immigration journey under the 10-year route. Somebody who is going through the immigration journey, 5-year route. Somebody who is going through the immigration journey and the EU provisions. At this stage, is the person settled? No. At any point in time, if you change your mind, you can become an overstayer. So you have to continue the journey and meet the requirement all the time to the top. Today's conversation is, when do you know that you have arrived? That's the question. When? Well, it can be all over the place. For every point in time, you have to sometimes ask yourself, hey, when am I even due to end all this hula baloo? And we are here to point you out to that bit. So as part of the basics, we understand that you have to go through the leave to remain or the limited process. Now you are due for indefinite leave to remain. How do you know that you have? The law says that you have to be able to have remained in the UK for 10 continuous years, legal residence. So once you have done 10 years legal residence, you qualify for indefinite. It says continuous under paragraph 276B. 10 continuous years, because there are some people who will not go through the tick box criteria, discretion. So with discretion, a bit here, a bit there, a bit there, all put together, 10 years residence. That is general. But for those who have specifics, 5 years, you qualify. So we say that you are due when you have done 10 years, but I'll come to that. Or you are due when you have done 5 years.
5 years,
Let's quickly touch on the 5. 5 for those who are entering the UK as spouse, or those who have switched as spouse onto the 5-year route. So simply for you, 5-year route visa. So if you're on the 5-year route, after the 5th year, you qualify for indefinite.
Okay.
When do I apply? You apply in the last 28 days. Because technically, if we are going up to the letter of the law or the rule, then we say that the 5th year should be the last day the visa expires.
Okay.
But common sense will prevail here. Why should a person wait to the last day? What if something happens and technical failure, they are not able to apply?
Then the person becomes an overstayer.
So the law says that you don't have to wait till the last day. You can do it in the last 28 days.
Could it be before the last 28 days?
Well, if it's before, then technically you haven't reached, gotten to the threshold of 5 years. Continuous residence. And so for those people who have no choice, you have to wait in the last 28 days. But for those who are on a 10-year route, potentially they might have been coming from somewhere, like a tributary of river, from all different streams.
Different angles and coming back together. Yeah.
So this person is coming from different angles up to the point of indefinite leave to remain, where person was once a student. When they were about to complete the course, they did PhD. When they were about to finish, they did something. They switched, they moved, they did that. All put together 10 years.
Maybe going to the family line as well.
They've tried everything. They are versatile. So they've tried everything. And putting all together, I realized that, I've even done more than 10 years. I don't even have to wait for the one I'm on currently to expire. But the rule says 10 years continuous legal residence. The ones that will not count will be custody leave. That one doesn't count. And also visitor doesn't count. But having entered the spectrum, and that's why those ones we're looking at, you come in as a seasonal worker, all those ones don't count. But there's no expectation that you will ever become permanent.
Okay.
So those ones with the expectation that you can ever become permanent, you can put all together, and it's up to 10 years, you can apply for indefinite. Even if...
No, hold on. Those ones that you didn't have the reasonable expectation that you will stay and become permanent.
That's no. I said, those ones that there was no reasonable expectation, then you don't have to.
You don't have
but
to.
The ones with expectation, a student, even though you came to study to return, you have expectation that once in the UK, because that's why if you are a student, mainstream, you can continue, switch, cut and paste, put together, 10 years, go on.
Okay. All right.
Yes.
Now, I still would want to. A student, yes, that's fine. Then reasonably, I change course, I do another one.
I even moved to parent route.
And come back into the student route again. And all those will come together. So if I come as a seasonal worker, for instance, and after 24 months, that's what my contract or the job required me, then I find another job, maybe go out and come back, find another job, and say that I'm going to work for another 24 months. That makes it 48 months, kind of. Getting to the 5 years. Can I reasonably say that, well, I didn't have the expectation to stay, but when I went out, I had the expectation to come back and spend another 24 months. Would that not count?
What is the expectation?
Coming to work and go.
As a seasonal.
Yes.
Coming to work and go, not to live. So seasonal workers don't contribute to the threshold.
But they take my taxes.
They take your tax because you use the road.
Anyway, well, that I raise my hands for it. That's fine. But still, reasonably, I expect that I can find another job. So after my temporary thing.
So seasonal workers are not like other skilled workers.
Okay.
They are a particular breed of workers. So they don't have expectation. That's why they are not considered as leading to settlement.
Well, if that's what law says, who am I to challenge?
So what's on this? So somebody can put all this together and say that, lawyer, am I due? I would say, how did you start? Your first journey as a student, where did it end? Was there a break? You moved to become a parent of a qualifying child. Then you became a parent, you became a spouse. Then you moved back to something. But we put all together and realize that you are on your last 2.5 as a parent again. But working back, you see that you've even done more than 10 years continuous residence, which all count if they must count. Then you don't have to keep waiting. Since you are due. So when are you due is when we see that calculating your time, you've done 10 years continuous legal residence in the UK. The route you have been
on. Right. So when I look at when I start, maybe we'll do some date calculation here if you permit us. When I start, on my BRP, it says issue date. And for me to go through the 2.5 years, which is 30 months, how do I calculate this? Is it the day after the date of issue, the date of issue on that day, or when? How do I start? And then I will just um, graduate to the various routes and do all the left, right, and backwards and all that to do that. The starting point.
Right. Okay, so the key thing is this. Once you are granted
Leave to
leave
remain.
to remain,
Mhm.
it will either be the 30 months, as you said, of course, at a point. You'll be given, before your BRP comes, you would have been told that it's been successful.
Mm-hmm.
That's the decision letter.
Okay.
If the decision letter, that's the deciding point, because it has a date.
Okay.
Before the BRP is issued, which may reflect the same date,
Mm-hmm.
even if the BRP date is different, the main date is the date
On the
on
letter.
the letter.
Okay.
So always ask for decision letter.
Okay.
The date is 8th of March 2025.
On the
That
letter.
is the date you were granted the leave.
Okay.
So the starting point will be that date. Then you switched without leaving it to expire
Mm-hmm.
to something. There will be another decision letter. So it counts. You switch to something else. You move here, you move there altogether.
Okay.
But the key point here is there should be no break.
Mm-hmm.
If there's a break, then it breaks the continuity consideration. Because the law says 10 years legal residence. So which bit don't count? One, you are in prison. It doesn't count.
Okay.
If you are in prison, you are as bad as being anywhere because you are not on the land, so to speak. So if you are in prison, then your liberties are taken away. So at that point, there's a break. If you come back, you cannot count towards. You can't say that I was in prison in the UK, so it counts. It doesn't count. So, for example, if you're in prison and you were not able to renew, and you come back and you start all over again, then you are starting afresh. If you become an overstayer, you didn't renew at a point, it also breaks, and all those things. But again, the consideration of paragraph 39E and section 3C come in here for those people.
Mm-hmm.
We know the case of Yeki, and we know the case of IFZA. Yeki and IFZA took the government to court, arguing that they are due for indefinite.
Mm-hmm.
The government arguing back to say they are not due for indefinite because there was a break within the 10 years continuous cycle.
Okay.
What was the break? One of them was given a chance to apply for fee waiver. Apply for fee waiver was refused, rejected.
Mm-hmm.
He was given a chance to pay and submit the main application. For whatever reason, did not do it in time.
Mm-hmm.
So there was a gap. The person applied to continue under paragraph 39E, which says that if it is within 14 days, you can still apply. But because there was a gap, because the person didn't apply or pay to continue the application within 10 days, it created a gap. And court concluded that because of that gap, you cannot benefit, even though you benefited from continuing with the visa application, which ended with another 2.5. Even though you are now 10 years in the UK, the last time when you failed to do what you needed to do, few days back or few days gap has created a break. And because it also delayed the Home Office, there was further time. And we put all together, and therefore you are not due. So we have to then deduct. So 10 years, if it's continuous. If it's not continuous or there was a break, then the break will have to be made up by further leave to remain before you are due.
Okay.
Again, somebody will apply. There's a case I'm currently handling. A person called me last week and said that, oh no, I applied for indefinite, and they said I should pay and submit application, and I should pay a top up to be given 2.5 instead of indefinite. I don't understand. So I said, well, we'll have to look into the case and maybe send a PAP. When I studied the records, on the document, asked for everything. He applied and was given 2.5 in 2022, September 12th.
Okay.
Then, when the thing was due, he renewed it. And when it was issued, so the first one was 10-year, 2.5 and a 10-year route. Then he renewed it by switching to 5-year route.
Okay.
So in his mind, I've switched, and so I'm going to stay on a 5-year going forward. So he got the first 2.5 under the 5-year route. Then when he renewed to stay on a 5-year route, he was given 2.5 this time on a 10-year route.
Oh.
So I said, hang on, there's inconsistency here. Yes. So you have 2.5 and a 10, 2.5 and a 5, and 2.5 and a 10. And you think that you are due because between the first 2.5 and the second one, which you think is still under the 5-year route, that will take you to indefinite. But because you were put under the 10-year route in the third grant of your 2.5, it appears that you are not due yet. It appears that you were put back on the discretionary route. So either the Home Office made a mistake and you didn't pick it up to challenge in time. Well, it was about 2 years ago. So you are too late to challenge. Or you didn't see, or you saw it and ignored. Could be a whole mix of reasons. So what we're going to do is to write to them to say there seems to be an issue here. And my client's instruction is XYZ. And so we want you to reconsider the decision and put him back because everything suggests that when he was applying the second time under the 5-year route, he still met the rules. He showed the English, he showed the money, he showed everything, and he was still not living with the child and the mother. He was still living as independent father, and the child was living with the mother separately, so direct access. So nothing changed from when you gave him the first 2.5 under the 5-year route. But what changed is that the letter of decision, it says grant of leave to remain, parent, 10-year route. And he didn't see that early. So I told him that, well, you didn't see, but it doesn't mean that is not what they gave you. So if you didn't see, I don't know why, but what we're going to do is to challenge them with the explanations you've given us, and we'll tell them to make, to temper justice with mercy on this occasion, and to make a reconsideration of the rejection of your indefinite. But the merit of your case is that they may say no. And if they say no, you have to continue there. But if it turns out that they say no without reason, then we'll again push them to reconsider because you can't say no without reason.
Well, if you have just joined us, Lawyer Charles Asma from BWF Solicitors is helping us to know when we are due for the indefinite leave to remain situation and what the law says. He's talking about going through several routes, he's defined the various terms for us, and then getting into some specifics. There are questions that you have, put them in the comment section. There, if you have the chance, you can call us on the line 0208-493-7345 or send a text message or WhatsApp message to 07399-208-468. We are live on the program The Community and the Law, and it's brought to you by BWF Solicitors. You can find us at BWF Solicitors on Facebook, at BWF Solicitors on YouTube, and at BWF Solicitors on at BWTV, so to speak, on Facebook and YouTube as well. Get yourself ready for the questions, and as well as is also ready, we will be having the answers right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We are ready.
Yes, we're ready and we're back, ladies and gentlemen. The community and the law brought to you by BWF Solicitors, our trusted partners when it comes to the law. Remember, you can call BWF Solicitors on 0208 493 7340. If you're in Ghana, you can call them on the Ghana number 055 589 5959. And emergency situation 077127 61884. I'm here with Lawyer Charles Asma from BWF Solicitors, and if you want to speak to him directly, you can call him on 07947 636037. 07947 636037. Do you know when you are due for indefinite leave to remain? I have somebody's let me say, letter from the Home Office, and now we would want to use that for the calculation. But in the meantime, let me go to the phone lines and see who we have on the line. Hello.
Hello, good afternoon, Brother.
Good afternoon.
Good afternoon.
Thank you very much for the program. Please, my question is, my husband is a British, and I'm due for the 5-year ILR application.
Mm-hmm.
And my visa is expiring. My BRP card is going to expire on the 3rd. Oh, sorry. My visa is a travel visa because the BRP is already expired on the 3rd of April. So I want to ask, am I due now?
So your BRP, yes, that hold on. BRP, we're not talking about that because that's expired on the 31st of December last year. But your status expires on the 3rd of April.
Yeah.
So you're asking whether you can put in an application now, or you'd have to wait for some time. But it's the 28 days. Are we calculating back from 3rd of April to where we are now?
Okay, so mommy, you are on the 5-year route, right?
Yes, please.
And your visa, which is the second one I have, expires in April 2025, right?
Yes.
What day, April? 3rd of April. Yes. So technically, 3rd of April is when you have your 5th anniversary, right?
Yes, yes, please.
But because you can't wait till the last day of the visa, you have to do it in the last 28 days. So if we go back, we're talking about say from 5th of. All right, we're already in March.
Mm-hmm.
Yeah, so you are due now.
Okay,
yes.
Thank you.
So from 5th of March.
I know the form is set M, but I'm doing it with my children. So what form should I use for the children, please?
Right. So usually when you are applying, they will ask if you have family, if you have others to add to that. So when you apply, go down, it will ask you, do you want to add dependent?
Yeah, I know that, but because I want to do my superviority because of work and stuff, and I want to do the children one, standard one, I'm doing my separately, and I'll do the children's one different. Yeah.
But these children are supposed to depend on you, right?
Yeah.
And when you are telling me that even though without you, the children cannot be able to do it, you want to take the train and they get on the bus.
Because of the money.
But they're going to miss the way, right? How can they get on the bus alone?
They go for a loan.
How can they go on the bus alone? I'm just using the analogy. You are supposed to hold you are supposed to hold their hands, right?
Yes.
So why will you go on the train and they get on the bus just for whatever reason? When they end up missing their way.
Hello.
Yeah, I'm here. I want you to understand what I'm saying, and you will say,
Yeah.
"Oh, okay," and they say. But I just want you to think about what I'm saying. I know it's because of the money. If the money is not enough, then but it cannot do it differently from theirs. They have to do it together. You are doing it, and you are doing it with them.
Okay.
Yeah, I mean, I don't. Yeah, so yeah, you want to go for priority and all that. But why do you want to go for the priority? Is it because of work?
Because apart from work, these days people complain that they don't get there.
Yeah, usually indefinite, there's no priority per se.
I've seen super priority and I did it all, but at the end, it was super priority for. We had said almost 12,000 something. And then the standard was 8,000 plus, but I wanted mine for the one and then the children.
But this is supposed to be a single or combined application, right?
Oh, okay.
Yeah, so if it's combined, I'm trying to give an example where something is combined and you want to treat one of them separately. Is it possible?
No.
And so you have to sit back and say, either all of us together super or all of us together standard.
Okay. All right then. Thank you very much.
You're welcome.
Thank you. Thank you, Bakuku.
Thank you too, and thank you for your time. Yes, you can also call in 0208-493-7345. Lawyer, we have the situation on hand, and I wanted to see if we can get some calculations done, if you would permit me. This was done through a law firm. So they sent that response to the law firm, which was forwarded to the uh, the client, and the client is brought in this for us to see if the calculation is done correctly. It says on the 28th of September 2023, you were told your application of 25th July 2023. So I am assuming that the application was put in July 2023, but the response came in September. So August, September, virtually 2 months after that. And the says for settlement in the UK would be varied and would be considered as an application for permission to stay once you paid the immigration health surcharge, which you have done now. You have been granted a period of 30 months limited leave to remain on the 10-year parent route under paragraph DLTRPT 1.2 of Appendix FM until the 11th of April 2025. then the conditions are given. So the calculation, when does it start? The 30 months that you're talking about.
Okay.
Is it the date on the BRP, or when the decision was made and the letter was given the 28th of September?
Right. Okay, I get what you mean. So what you are saying is that assuming this is the beginning of their leave, will we use this date, 28th of September 2023,
to do the
or we use the
calculation?
BRP date?
Yeah.
We use this date. So that's when the leave was granted.
The 28th of
The 28th of
September
yes,
2023
is the beginning of the count of the period. But for this person, it's not that the person is starting all over. So we have to go back. Because when they made the application in July 2023, they were told that they didn't qualify for indefinite, but they haven't done continuous 10 years. So they were given 2.5 again to make up for the shortfall. So whilst they are waiting for the last 30 days to be up,
30 months.
Oh, sorry, 30 months to be up, we have to go back and check when they were first given the 2.5, which they thought they were due for indefinite in July.
Oh, okay. So then the previous letter should be referred to.
Exactly. The first, second, third, fourth, whatever. Because he thought that he had done four seasons or 4 2.5s. And they said, no, it's not up to 4 or it's not up to 10 years. So we'll give you indefinite. We'll give you a top up again.
Okay.
Because it will not be fair for you to become an overstayer.
Okay.
So we'll give you a top up, pay the difference, which is the IHS. And that's the example I gave you, my client. So my client was told that you don't, so pay the difference. He thought that he was due because he did the first 2.5 on the 10-year route. Maybe he will take the call and continue.
Yeah, we'll come back. Let's take this call. Hello.
Hi. Hello.
Yes. Good afternoon.
Good afternoon, sir. Good afternoon, brother.
Good afternoon.
Yeah. Please. I'm listening to the program, but some of the my understanding is a little bit technical. I'm on the 10 years route. Through I applied it through the children and then was given through the spouse, and it's my last of the 10 which I have done. In this case, must I have to wait for the last 28 days before I can apply for indefinite, or I will have to wait for the entire 10 years to be exact before it's due to the breakup discussion explanation you are giving. So if you can really clarify that area for me.
Thank you.
To understand, please.
Thank you, sir. Was there, so are you there, sir?
Yes.
Was there ever a break between the 2.5s?
No, I have never had a break.
But there's always the case that it will overstay at the home office, right? Delayed.
I'm sorry, say that again.
I'm sure there were delays when you apply. Some of them, it will take some time before they will give the decision.
Okay, yeah, sometimes it takes late before they give decisions.
And it's possible.
But I do most often I do apply sometimes 2 months before the end of the period.
Yes. Well, what I want to assure you about is that because it delayed at the home office sometimes before decision was made, if you at the moment count all your legal residence from day one, you realize that you might have done 11 years, including the delays. True. Are you with me?
I'm a little bit confused.
Okay, what I'm saying is, at the moment you are waiting to have 10 years continuous residence, 2.5, right?
Yes.
But if you tell me, when did you have your first 2.5?
That was in 2018.
So let's 2018. So let's count.
Yes.
2019, 2020, 21, 22, 23, 24, 25.
Yes.
Now we have to check the date. Which month in 2018?
I was given on the 14th of I'm sorry, the date itself I have forgotten.
In what month was that?
That was issued.
In what month was that?
I think it was in April.
April 2018. Yes.
So this is your third 2.5, isn't it?
No, this is my fourth one. My fourth one I have had. So I'm waiting to 2027.
Right. So the fourth one has just been issued.
Yes.
So now let's continue. So 25, 26, 2027 will still be about 9 months. Sorry, 9 years.
2 years.
No, it will still be so either you had it before 2018 or there is a date you are not sure about. Because I was trying to count time to see whether you've done 10 years. But 2018 to date is not 10 years. And 2018 to 2027 is not 10 years.
No, I applied. I was given in 2018. I was issued in 2018. The application was done in 2016.
No, the date you were given.
2018, the first.
The date you were given, 2018, right?
Yes.
So 2018, when are you going to be 10 years? That will be 2028, yes. Right?
Yes. It's falling to 2027.
No, I'm not talking about what you are giving now.
Okay.
I'm talking about general timetable. 2018, 10 years will be 2028, isn't it?
Yeah.
So, either Home Office miscalculated and gave you less than 10 years by 2027. Or there's something that you haven't picked up properly. So if you want us to really go into the dating order for your case, call later on, we can discuss it. Okay. But as far as the facts are concerned, what you've told me is that from 2018, when are you going to be due for indefinite? You'll be due for indefinite in 2028. That's 10 years continuous residence. And it also tells me that it appears that as soon as you apply, they gave you decision the next day, which is always not the case.
No.
So if we are to count the delays, then it even go beyond 2028 by the time the last one. And that's why I was saying that maybe there's something that you are not clear about or you haven't picked up. So please go and look for your first 2.5 and let me know when it started. Then we'll take it from there.
I will do so.
All right.
I will do so. Thank you very much.
Okay. Right. I can appreciate the challenge people are having with the calculation because it's not very clear, and sometimes people do not take note of when the first decision was made, and then also the confusion between the date on the letter and the date on the BRP, which may not be the same. And I think that's where people are having challenges with that.
Yes.
So what do we look for? The date on the letter or the issue date on the BRP?
The date on the letter.
The date on the letter.
I always say that we have the body of your visa and the spirit of your visa.
Okay.
Or the soul of the visa.
Okay.
The soul of the visa will be the visa itself. The body will be the container. So the fact that your BRP has expired 31st of December 2024, they said there will be no BRP, doesn't mean that you don't have a visa. So the visa is somewhere, which is the soul of it. And the soul will be the actual letter you were given when you were granted.
Okay.
Whether you had BRP or your BRP is missing or your BRP is cancelled, you have the soul there. And it's the soul that is the being of your visa.
Okay. So people should at least be looking for the original letter where the decision was made.
And then we can count the date from
the date.
Because the BRP always comes after the decision has been made. And you've been told. And they will say your BRP will come in 14 days or blah, 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 10 days. Then people go, oh, lawyer, my BRP is still blah, blah, blah. I got my letter last week or 2 weeks ago. I'm still waiting for my BRP. So we are likely to have different dates. Because once the letter is issued, which is a decision, somebody will have to print the card.
Which will take some time.
So it's always the date on the letter.
0208-493-7345 or 0739920846. That's for our WhatsApp and text messages. We've got a friend on the line. Hello.
Hello, good afternoon.
Good afternoon.
Yeah, can you hear me?
Yes, very well.
Yeah, my name is Isaac from Reddit.
Yes, I.
First of all, I have to applaud you guys for a good job.
Thank you very much. Thank you. That's the whole essence of this one.
Sure, thank you. And before I go to my go to my question. My wife in Ghana tried your Ghana number several times, but it appears it's not going through. There's a problem with it.
A problem? No, I don't think so.
Yeah. So.
Okay. We'll put the number back on the screen, but it's working. I know it's working.
Okay, we tried out.
Okay. So yeah, what you can do, if your wife is still having challenges, call the office number here in London. You can call the office number here in London. We can route it back to them.
Okay, so I'll do that on Monday.
Okay, sure. Now let's hear your question.
Yeah, my question is talking about this leave to remain. For instance, if I'm on a 5-year rule for a skilled worker, like me, I'm a skilled worker, and by the end of the 5 years, I have conditions of work. Maybe I'm not entitled for public funds. I'm supposed to do extra 20 hours per week. Assuming I've brought those laws, for instance, I'll go in for public funds, or maybe I do more than 20 hours per week. What will happen if I'm going for my indefinite? Assuming I've been refused because I've flouted those laws. Do you have any way of staying here again? Can I go for another COS? And if I go for another COS, will I be refused again because of what I did previously? I want to know if I'm refused at the end of my 5 years, what are my options of getting the indefinite? Because maybe I break some of the rules or the conditions of my visa.
All right. Thank you very much, sir. To be honest with you, if I were to give you response to your specific question, it will require you to disclose personal information which you wouldn't want others to know. How did you get to do more hours elsewhere and blah, blah, blah. So we don't want to discuss that here. What I would suggest you do is that give us a call. We'll give you bespoke advice. That is, if you still want it, so that we can discuss. I will need more detail, more information, and tell you that if this is happening, this is what you have to do before you get to the point where you wouldn't, where it might be too late. Okay.
Oh, okay. All right. Thank you very much.
You're welcome.
Okay, yeah, I know today the phone calls are plenty, so we haven't even had a chance to pick up the text messages and the comments on the comment section. So we'll take this one and go on to the comment section and pick up a few of them. I promised a few people that I was going to do that. So this will be the next call and the last one, then we'll go to the comment section. Hello?
Hello?
Yes.
Good evening, Chief.
Good evening, boss.
Lawyer, also thank you for your services to the community. Please, I want to quickly ask this. I'm on skilled workers visa. I have worked, I was given 5 years EOS. So unfortunately, after 2 years, there is a break. Prisoners, the company's license being revoked, which we have gotten an assurance from council that they may help us with another COS. So now there is a break for somewhere, there may be a break for somewhere 1 year. That break, that although my skilled worker have not been revoked, would that break, that is working, there is maybe a break in work, that the indefinite leave to remain after 5 years. That is, if I get another COS, continue to the 5 years. Would that break? Yes,
No.
Okay, all right. So I'll take the opportunity to touch base on. Are you there, sir?
Yeah, I think his line is breaking.
Yeah, he can. So answer him. All he's asking is, how does 5 years to settlement and the skilled worker route works? And I'm sure people have similar questions. Because we didn't touch up on that, let me quickly touch. Now, regarding skilled worker, when are you due for indefinite as a skilled worker? You come in with the expectation that after 5 years, you apply for indefinite. But there are specific rules around that. When you are applying for indefinite leave to remain as a skilled worker, your employer must still confirm. If I say employer, the last employer you are with, or you might have switched employment. The last employer you are with must still confirm that they need you after your indefinite. And they have to confirm that, yes, they can confirm all the things that ought to be confirmed, including salary and everything else. So confirmation means a letter must come from them. Confirmation means they have to confirm that they have the hours to still engage you. The confirmation also means that you have been with them or you have continued from somewhere with them up to this point, and then they support you with necessary documentation. If you are not able to do that, you will not be granted indefinite, even though you've done 5 years on the skilled worker route. So, whilst in other categories, when you are due for indefinite, do it yourself without some specific support per se. With this one, you still have to prove that the employer needs you. And that makes it quite a challenge for most skilled worker migrants, because you've done 5 years. Maybe you did 2 somewhere, you did 3 here, or done 3 here, you are due. But the last one, the last employer must still be able to vouch for, to the extent that you are still needed in the UK to be able to perform that job or role. If you are no longer needed in the UK, then you will not be granted indefinite leave to remain, even though you've done 5 years. So those are the specifics to do with with skilled worker. Otherwise, having done 5 years on that route in that industry, adding from previous employer to the current employer, you can apply with the help of the last employer for indefinite leave to remain. You have to still meet the rules.
Well, I think I mentioned that we'll take about a couple of comments from the comment section down below on Facebook and YouTube. Get quick access from that. Kofi says that my partner is due for her indefinite leave to remain on the 10-year partner route. She, however, has a CCJ on a private debt. Is that going to affect the decision, lawyer?
Well, some of these specifics, I know CCJs do not affect suitability. What sometimes becomes an issue if it is IVA, or that is an individual voluntary assessment for, let's call it bankruptcy. So bankruptcy, if you are declared bankrupt, then that will affect to an extent indefinite leave to remain naturalization. But CCJ, I mean, some of the CCJ are so useless in terms of how they happened. It might be that it was even a parking thing. You didn't even know that somebody has taken you to court, because these applications are done online, and it goes to county court in Northampton and Catherine, and by the time you realize you are on there, you've gone past 28 days, so you can't even challenge it. And even though you have challenged it, you might have even paid the money, and it's still showing 6 years. You don't have to worry. CCJs, no.
Okay. Well, Kofi, thank you very much for your comment and question. Yes, that's been answered. Okay, McDonald, what form can you use for children application of indefinite leave to remain family route?
So with children, we have set F. Set F for children.
Okay. Maybe you can take the last one, because we're running out of time, unfortunately. My naturalization application has been successful, and I want to apply for a British passport. And filling out the form, there's a question which goes, have you ever used any other names? What exactly does this mean? Are they referring to names I previously used in making home office applications, or names I officially changed on my documents? Well,
if Home Office is asking you, then they're asking you whether you have ever used a different name with us.
Okay. So then, if
so you have to tell them.
You have to tell
them. It might be that when you were coming, you came as John Mensah. When you then you got in, you changed your name to Charles Mensah. Then at a point, you became Robert Mensah. These are all different names by the same person. You may have evidence of that. So when they said you have previous name, I think even your previous application, they ask the same question. Every application, they ask you, do you have previous name? So if you do, say yes and give them the details.
Well, I wish I could go on, but I'll give lawyer one bit of that to add to it. Then I'll bring back my nugget and my question. Pick your answers before we draw the curtains down. Learn.
Yes, so quickly, our brother who called and we said we'll touch up on the skilled worker. I think what he wanted to know is that if there was a gap, how does that affect me? If I worked in a second job instead of 20 hours, I did more than 20 hours, can they pick up? And if they do, and I'm refused indefinite, what do I do? It all depends on what happens. So if you are refused, that's when you know what to do. So I don't want us to preempt that and respond to that future bit. But what I'm saying is that if you are supposed to do 20 hours and you did more than that in other areas, that means you are in breach of your condition, as you rightly stated. If they find out, that may be an issue to be picked up. If they don't, then I suppose that is it. But it all depends. Nobody knows what they will pick. But obviously, you know that you have offended at a point. And if there was a breach of a condition, that can be something that could be used in future applications against you.
A word to the wise is always enough. Thank you very much. Now, those of you who missed the beginning of the program, we talked about child maintenance service, and we asked you the question whether you knew whether you see your child or not, you have a legal duty to support that particular child. The Child Maintenance Service can take enforcement action against the non-paying parent, either through a deduction of earnings, order or a court order, including seizure of goods, disqualification from driving, and court metal. But before I go, that let me give you the scenario. Let me give you the question again. Mokoso briefly dated Leila, and they had a child called Zaina. Zaina requested that child support be given from Mokoso to Zaina, but he refused, claiming that he's been denied access to their child. The case was brought to the Child Maintenance Service, which determined that Mokoso should pay £450 per month based on his income. However, he refused to make any payments for 2 years. Arrears. What options are available for Leila or the CMS to collect the arrears? Urgent to pay as the child is in need? There's nothing. Since Leila has denied him access, he has the right not to pay, or potentially pursue legal action to imprison him for non-payment. Now, there's one particular question I want to quickly bring to. So look at this. One particular question on the platform. It was sent on our text message line. It says, good evening, Braku and Lawyer Charles. What is the difference between LTR and right of abode, and can I get the right of abode first, or have to get LTR before I can apply for right of abode and also apply for my British citizenship? Is it advisable to get right of abode before your British citizenship? I think that's the main crust of the question. As they consider my question, please answer their question.
Okay, sure, I agree. Okay, yes. So I'd rather right. Okay, so LTR is leave to remain, leave to remain, limited leave to remain. So you have leave to remain in the UK. If you are entering the UK, you have leave to enter, LTE. Now, right of abode is somebody entering the UK with citizenship. Okay. So once you are entering, so obviously you might be a child who qualifies for passport, but for whatever reason, if you apply for the passport, it may delay. So you can apply for right abode, enter the UK, and instead go through the process. So right of abode simply means that you have the right to be permanently resident in the UK, and if that is the case, you are already, whether you are entering with the right of abode or you have already entered with a right of abode. What then do you do? Having had right of abode, you can then apply for citizenship. Or having had right of abode as a child, you can then apply for the relevant documentation. Which one is better? The second part, can I apply for right of abode and also apply for citizenship? Is it advisable
Right
right
of a
of abode?
vote before citizenship.
Well, I mean, I suppose if you are, I'm not sure what the person is. If the person is outside the UK, the right of abode will give them chance to enter the UK as if they have permanent residence. And once they do, they'll go through the process. So if you're already in the UK with leave to remain, then you cannot apply for right of abode in the UK. But you apply for right of abode from abroad to enter the UK instead of applying for leave to remain, leave to enter. So I'm sure there is something that you know which you were not able to share for confidential reasons. If it's something you want to share with us later on, call us and we're able to listen to you carefully, ask follow-up questions, and we can advise which is the best option within the rules.
Then, as a follow-up to the wonderful piece of advice that Lawyer Charles Osman is giving, I'm going to ask you to give me your answers. What options are available for Layla? Susan says, number one, urge him to pay as the child is in need. Who else? Max Obefi says, nothing, since Layla has denied him access and has right not to pay. Next, we have Frank Darko, number two, nothing. Well, really nothing? Okay, let's see. Tilly says, number one, urge him to pay as the child is in need. We have a Kriakredu potentially pursue legal action to imprison him for non-payment. Well, that's number three. Who else? Dennis Bediako says, number two, nothing, since Layla has denied him access. He has a right not to pay. Sarah Biney says, number three, potentially pursue legal action to imprison him for non-payment. Florida also thinks same. Number three. We go on to Amma Japoma, number three. Thank you, Amma. Next, Kwamlemchi says, number one, urge him to pay as a child is in need. Kofi Nyako, number two, nothing. Since Layla has denied him access, he has a right not to pay. Bafuri says, number one. And for time, I think I may take the last one. Yeah, Collins also says number two. Well, today, straight away, what can Layla do?
I think it's if we look at this carefully, urge Layla to urge who?
Mukoso.
To pay.
Yeah.
But he hasn't paid for
2 years.
2 years. So why would he pay now? So it's not about the edge. Already we know that Layla can report. And if Layla were to report, certain things can be done. So in that case, it's not about Layla. So if you look at the potential options, we'll go for the fact that Layla, if he wishes, she wishes, can pursue, and Mukoso can be imprisoned if that were to be done. So three will be under the circumstance.
Potentially pursue legal action, yes, is the answer. You know, in England, the Child Maintenance Service can take a parent to court for unpaid child support and apply for a liability order. That is according to the Child Support Act of 2023. This one says enforcement. Where there is a willful refusal to pay when the absent parent has the money, the court can issue a liability order and subsequent committal order, which can send the parent to prison for up to 6 weeks. 5 and 1. I wouldn't want to go in for a day because it impacts my record. Well, that's that. A word to the wise is always enough. And by tradition, we would ask Lawyer Charles Asma from BWF Solicitors, our proud benefactors, to give us a summary of what we discussed this evening.
Thank you very much. So, viewers and listeners, today we looked at when do you think you are due for indefinite leave to remain? You are due for indefinite leave to remain if you have stayed, for example, on the 10-year route. In the last 28 days, you can apply for indefinite leave to remain. However, you have to check that there was no break. If there was a break before a certain application was made to renew, then you will not be due when the 10 years up. You'll be due by making sure that you have made up for the difference between your delay and the Home Office delay. So take note of that. That is the case law position. The next one is that if you were on the 5-year route, again, if there was a break, you have to make up for it. If there was no break, then you are due, you put in your application for indefinite in the last 28 days. Can you do it before that? Technically, no, because if you do it before that, before the last 28 days, you wouldn't have 5 years up to be able to count the time. So in the last 28 days, for skilled workers, 5 years on the job, but again, the employer must confirm that they still need you. And if they don't need you, you cannot apply for indefinite. So if you're a skilled worker, resident in the UK, traveling on holiday is not leaving the UK. So don't worry if you are in and out. But if you are out for more than 6 months, then that's again an issue. So skilled worker, 5 years on that. Employer has confirmed. Then in the last 28 days, you can apply for indefinite leave to remain. Again, EU, pre-settled, in the last 28 days, you can apply for settled status. Again, if you are EU and you are applying under retention of rights, don't apply for indefinite as soon as you divorce your wife or you divorce your husband. Wait until the 5th anniversary of the marriage before you can apply for settled status. These are the areas that we have touched upon. If for whatever reason our responses were not clear to answer specific questions you have or you had, feel free to get in touch and we'll be able to continue with you personally on consultation basis. Thank you.
And thank you very much, Lawyer Charles Asma, on behalf of our viewers, listeners, clients, and the whole community. Thank you for your time and thank you for coming to do this for us. Thank you to BWF Solicitors for allowing us to get this over to the community to make sure that we get empowered. And to you out there that listened, that participated, and also sent in your questions, I want to say thank you very much. Without you, we don't have a program. And to the women of our lives, it is International Women's Day today. We appreciate you and we salute you and we urge you to continue to do what you do for us because without you, the society is dead. To my studio producer, Professor Ade, to Shilankra and Padma Dudu, and to everybody that's been part, thank you. We'll be back again same time next week. Until then, be good.